Good afternoon, everyone, and welcome to the November 24th, 2025 Committee of Bar Examiners Subcommittee of Examinations Administration meeting. As a reminder, this meeting is being recorded. Devin, at this time, I'm calling the meeting to order. So, Devin, can you please call the roll?
Howe,
Here.
Kongora, not present. Kramer,
Present.
Smith,
Present.
Yokelson.
Present.
We have a quorum.
Thank you. As required by the Bagley-Keene Open Meeting Act, members are to appear visually on camera during teleconference meetings, except if a member is unable to appear by video due to connectivity challenges. We ask that any members who are present with their cameras off state their names and reasons for not being on camera. Additionally, if a member joins a meeting after roll call, they should raise their hands virtually and notify the chair and members of their presence and the public of members of their presence. If the camera is off, they should provide an explanation. Members should also raise their hand when leaving and returning to the meeting if they will be absent for more than 5 minutes. Next on the agenda is a call for public comment. Before we begin public comment, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or related to matters that are within the jurisdiction of this agency. Specifically, the subcommittee exercises oversight of the administration of the California Bar Examination and the first-year law students examination. The subcommittee does not have authority over attorney discipline, and there are no attorney discipline matters on the agenda for today's meeting. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the subcommittee would have time to consider these comments. The subcommittee has received and read all the public comments that were received, and we thank you for that. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers. We don't have a high volume today of speakers, so I'm not going to limit or make a motion to limit the time beyond 2 minutes. For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom of your screen. If you wish to address the subcommittee, please click on the hand icon now, and the committee coordinator will call on you in the order that hands are raised. For those of you that are participating by phone, you may virtually raise your hand by pressing *9, that is the star key, and then number 9. Again, doing so will alert staff that you would like to make a comment, and the committee coordinator will call upon you and open your microphone so that you can address the subcommittee. For those who are participating from a notice location, please alert the committee member of the state bar or the state bar staff present in the room that you would like to make comment. At this time, there is nobody present here at the Los Angeles office. Is there anybody present in San Francisco, Julie?
No, Alan, no one present.
And is there anybody present at any of the other sites? Mr. Kramer?
Yeah, we have one person here in Davis.
Okay.
You ready for him?
In just one moment. So
Okay.
staff will have an on-screen countdown timer visible to all attendees during the duration of public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash through the final 10 seconds. So at this time, Devin, is there anybody who signed up in advance for public comment?
We do not have any advanced signups.
All right. Regarding the person who was present, I have Mr. Kramer's location. If you'd like to speak, now is the time.
Good afternoon, all members. My name is Kai Ong from Sacramento. I would like to share a integrity issue of State Bar. Last time I already talked about State Bar keep delaying process of my complaint. And after last meeting, State Bar closed my complaint without reviewing the DA case number 99F08735. My father, Win Kong On, is the victim of the case, and Jung So Fong was the driver that killed my father. All members, you joined the State Bar Committee is to help to build a healthy and integrity law system, legal system. However, State Bar have integrity issue. How State Bar can regulate the student to exempt the student and regulate the licensed attorney. I'd like to share this story because what you are doing is contradict with the purpose of the State Bar. I hope you can help to notify this incident to all the legal profession, all the law school, so people can uphold the justice and to look into why State Bar will have this kind of integrity issue. Thank you.
Thank you, sir. Are there any other, there are no other persons at any of the other locations wishing to speak. So Devin, will you now call on members of the public who have raised their hand, if there are any?
We have a hand raised. Our next public comment will be from Benjamin Cohn.
Thank you. Mr. Cohen, you have the floor.
Hello, I wanted to address that the agenda for this meeting seems to reflect that, in general, that Prometric is doing an existing relationship with the State Bar for exam administration for the first year's law students examination. And I personally have found them to be a much more reliable vendor in general at implementing high stakes exams. So I think that some of the issues that were talked about at a board meeting recently to do with the reliability of vendors and whether you can have certainty or predictability about whether a vendor could or could not implement, for example, a remote exam is based on measured having been unreliable, is not really that on point, because you have a vendor that you're using on a recurring basis that you found to be reliable, that you have a proven track record with this first year law students exam, and that has done that exam remotely many times successfully. So I think that is the proof of concepts for the question of whether, the feasibility question for the remote exam as expanded to the California bar exam. I also wanted to address relatedly that there is still some amount of confusion over the circumstances under which the State Bar in Committee of Bar Examiners has the option and when they would have the option to make a transition to a remote exam. The notice statute for remote that specifically calls out remote exams is only for testing that's not at the option of the applicant. So that doesn't apply to a hybrid exam. It would not stop you at all in its terms from offering some people in person, some people remote, depending what the applicant wanted to choose. What does stop you for the standard condition is the NCBE's policy in the 18-month deadline to drop them to the extent that it is enforceable. But there was some confusion as to whether you could depart from that for testing accommodations that the NCBE was not going to allow at the last CBE meeting. And the idea that you would need to administer a different exam for other people to do that is not the case. You would be able to go back to Kaplan on the basis that the statute is for NCBE 18-month notice to drop is preempted if the NCBE chooses to enforce the policy that was referenced in that resolution, thereby meaning you don't have to give notice to use the Kaplan questions. Thank you.
Thank you, Mr. Cohen. Next speaker.
We do not have any additional raised hands.
Okay, thank you. Then thank you, everybody, for your public comments. This concludes the public comment period. At this time, item 1.1 on the agenda is the chair's report. The first item is, I want to take this opportunity to thank everyone on the subcommittee, since this is our first meeting. As a reminder, this subcommittee is charged with overseeing all aspects of the operational delivery of the California bar examination. The subcommittee's primary charge is to ensure that the administration of the bar exam is secure, technologically reliable, user-friendly, accessible to all applicants, and compliant with applicable policies and standards. We will also oversee the operational delivery of the first-year students' examination. Today, we will be approving the business requirements and evaluation rubric for vendors to administer the first-year law students' examination, beginning with the October 2026 administration. We will meet again in January to review the business requirements and evaluation rubric for vendors to administer the California bar examination, starting with the February 2027 administration before the joint meeting with the Board of Trustees on January 23rd, 2026. So we will meet first, and then there will be a joint meeting with the Board of Trustees. Once the business requirements and the rubrics have been finalized, the State Bar will include them in a request for proposal for each exam. Vendors will have a set time frame to respond to each RFP. After reviewing the submissions, the subcommittee will meet to discuss our evaluations. For the first year students exam, we expect to meet again in late January or early February for demonstrations and/or presentations from vendors. And that concludes my report.
Can I ask a question or two?
Yes, sir.
Are the January and February dates not yet firmed up? I'm trying to make plans. This is ski season after all.
The dates are not firmed up. Devin, what is the status of that, or Tara? You want to take that?
I think we do have the dates for next year scheduled. We just still need to finalize the locations of the meetings. But we'll have an update at the December 5th CBE meeting, if not sooner.
Yeah, is there any way?
I've reserved the room here in Davis for those, so I'm good.
Okay. All right. Any other questions?
Well, yeah, one more. So if we're talking about the bar exam itself in February of 27, we won't even be meeting with the Board of Trustees to make further efforts toward a decision about what the future bar exams are going to look like. So is that perhaps premature, or is this a temporary contract for the months between the end of current contracts and whatever the new exam turns out to be?
Yes, and I actually thought we were talking about February 2028. So, yeah, Tara or Devin?
So we've contracted with ExamSoft to administer the bar exams next year, so just for 2026. And so it's the latter of what you said, Paul. It's just in the interim until we decide what the next step is. that we needed a vendor secured.
Okay, thanks.
All right. Moving forward then, item 2.1. Next on the agenda is approval of the business requirements for delivery of the first year law students exam and approval of the rubric for assessing the ability of vendors to administer the first year law students exam. Staff, who's going to take this?
I will. And so I'll just give a brief overview and then we can open it up for discussion. And so thank you everybody for joining us today. I apologize that the materials didn't get up till Friday. We'll strive to do it a little bit sooner in the future. And so today that we are asking that you approve both the business requirements as well as the rubric, as Alan mentioned, those will then be dropped into the request for proposals for the first year. We anticipate that would be posted in early January, giving the vendors about 20 days to apply. And so due date is roughly right now, January 24th. And then the plan is that after this meeting, I'll send out an email to ask for 2 volunteers from the subcommittee to help review the proposals. After that, the volunteers, as well as myself, will rate the proposals. We'll bring it back to the full subcommittee for review, decide if we want to do demos for all the top couple, whatnot, and then move forward from there. So we do need this vendor starting in October of 2026. And so right now our tentative work date for the vendor would be June 1st of 2026, which is why it's a little bit of a quick moving pace, but we do appreciate your time in the review that's going into it. And I think unless there's any specific questions, we can open it up for discussion.
Do we have any specific questions?
Oh, yeah.
Paul.
Yeah. I apologize for the time this is going to take, but I don't see any alternative. Sometimes on these things, if staff gets it out far enough ahead, I'll mark them up and send it to staff, and we don't have to discuss them in public if they agree. Although that's still not ideal because it means other members of the committee are maybe not participating as fully as they would like in that iteration of the proposal. Anyway, couple general comments. Maybe this isn't the time, but maybe in December, Donna, we can talk about what these 2 subcommittees are going to be doing in a sort of proactive way rather than something like today, which is basically reactive. In other words, are we going to see the bigger picture and be able to influence that rather than kind of chipping away at the details when after they've developed an amount of momentum that tends to resist change. But you don't have to answer that today. It'd just be nice if we can talk about that in December. There is an undercurrent, a general theme here of trying to get a product that can be scaled up to also administer the general bar exam. And you see that in various places. Scalability is one of the factors. I wonder, though, if that doesn't discourage applications from companies that are capable of servicing our relatively small numbers for the first year exam, but would be daunted, especially after what happened to Measure Learning, in committing to be the remote provider for the full bar exam. I think that's kind of a policy question, but I would be in favor of de-emphasizing, trying to identify the next solution to a problem that or a need that we are yet to fully define, and just make sure we've got somebody that can do the first year exam without drama. The proposals or the requirements, I think, need to speak more to information and capabilities for remote proctoring. That of course is where February went so wrong, in one way at least. And also another thing I think that needs to be fleshed out is the need to have video records of those remote sessions. It's implied by but it's also, as the requirements are currently written, it's really more of a suggestion that if they have recordings, they have to keep them for us. But I think somewhere we need to say that they have to make them. Because if there is a problem that we have to troubleshoot later, we need to be able to, at least the opportunity in the appropriate cases, to be able to see those recordings and see for ourselves what is going on. I have more specific comments, but why don't I start with those and see how everyone reacts to that?
I can respond first, Paul, to the scalability part of it. And so this is partially where the staff recommendation was to give that a lesser rating on the rubric. So not evaluating as significant as some of the other things, such as candidate experience, but then also not disqualifying somebody if they can't meet up or one of the criteria. So for example, if you said there is maybe a smaller company that might be able to administer the exam for us, they meet everything else or exceeds everything else, that one not applicable or below rating wouldn't preclude them from being our vendor. I think it's something we included since it's been part of the conversations with the full committee. I know that was something that was mentioned, I think, during some of the vendor presentations before we contracted for 2026.
Okay, but if it gets any points at all, it could be a thumb on the scale.
So I would note that when the committee saw the presentations from vendors for the bar exam in September, there was a discussion at that time about, well, wouldn't it be, good if we selected different vendors for the first year law students exam or the legal specialization exam as a way to pilot or test out different vendors who may be able to ultimately do the bar exam. And so that was part of what was on our mind, wanting to have some ability to look at vendors based on CBE's input as a way to see, is this a vendor who could scale up ultimately and do the bar exam? If the subcommittee wants us to take that implication out of the requirements, we can certainly do so. But that's just so you understand where the impetus for that came from.
Oh, I do, because there's many people seem to be hoping or thinking that we can just demand that somebody figure out how to do that without problems, and by sheer force of leadership, cause the problem to be solved. And I am very skeptical. I think it's going to be a hard problem, just because of the economics of it, because it's only for 4 days a year. And members of the Board of Trustees are some of them are speaking in those terms as well. I very much prefer that. First of all, we're only checking the ability of the software to give multiple choice questions, not to collect written answers. So this is a pretty incomplete test of a product for other things that we don't need right now.
Which is why I think Taro was saying that its scalability is gets low attention on this.
But should it get any? That's my point. Because if we have two vendors of similar, who score similarly on the needs of the moment, should scalability be? Should it be a factor?
At all. Okay. Thoughts? Staff, was it, Donna, was it the committee's impetus that put this in there, or does staff have any thoughts of why this might be beneficial to consider scalability at all?
Yeah, I mean, it certainly was informed by the discussion of the full committee when you were having the presentations from the other vendors about sort of the idea of using these other exams as a way to pilot, if you will, just or not even pilot, but to see what these other platforms might look like, how they might work, get an understanding of that. If I think we're always interested in scalability, right? We'd love to get to know a vendor, work with a vendor, and not, keep changing vendors every couple of years. And so, we're always interested in something that would be scalable and used for a different purpose. But again, this is why this is coming to the subcommittee, is you get to say, we don't think that's important and you should take it out.
Thoughts from other members of the subcommittee?
For the scaling, I noticed that if there was 2 areas that a vendor was, I forget the term now, not meeting the standards, then they would automatically be not eligible for it. Could we have scalability kind of like a bonus? Like if they don't meet that requirements, then that doesn't count against their 2, but kind of like if they are able to scale in the future, that's kind of something that we can consider. If it's between them and someone else, it's kind of like maybe like extra credit or something for them.
Yeah, in effect, you're saying extra credit kind of overrides the basic deficiency. Would that be appropriate?
So I do want to be clear that generally our RFPs provide that the bidder with the highest score, if we're going to award the contract, the bidder with the higher score would be the one that we would award the contract to. So I think that would be true whether you call it sort of extra credit or it's part of the rubric.
No, but I think she's saying maybe then they could have 2 D or F grades, and still possibly, because they're so wonderful in all the other areas, be the awardee, and that's not what the proposal says right now.
Right now it says D or F and 2 or
You're
more,
out.
and you're out. Yeah. Well, first of all, procedurally, how do we go about, Donna, changing the proposed business requirements here? I mean, do we amend the attachment?
Yep.
How's that work?
Yep. This is just like any resolution that you would do, adopting rules that were proposed in a staff report, an attachment to the rules. So you'd do the same exact thing. You'd make a resolution to adopt the proposed business requirements with the following exceptions or changes, or as amended, as discussed today in this subcommittee.
So in essence, I think what what you're saying is we take this one step at a time, not get ahead of ourselves. And by injecting scalability here, we're in essence getting ahead of ourselves or leaving that possibility open.
Yeah, and maybe causing some people who would bid to to not bother, because they know they either don't want the risk or the headache or the hassle of doing a much larger scale exam.
What's the downside of taking this out, Donna? I mean, it doesn't really seem like it would set us back with respect to the general bar exam.
I'm going to defer to Tara because Tara's actually leading this effort and I keep talking. So I'm going to let Tara take the lead on that. I can fill in as needed.
Tara, go.
Thanks, Alan. I think it's just everything you've heard from us already. If we don't have this in the rubric and we take it out from the business requirements, you may not get that information from the vendor. So if it is something that committee ultimately wanted to see to consider for the bar exam, we just wouldn't have that information up front. It's always something that if we choose a vendor, we could ask them for later. It's just, it won't be available to us at the time.
Well, I'm thinking that at the time we go to the next step for the general bar exam, then we would ask for this, obviously, because that'll be a major consideration. How deliverability to however many applicants there are. So I don't see any downside to removing it. Any other subcommittee members?
Because staff wants that information, could we just make the points a lot lower? Like they get 1 point maybe if they meet or exceed expectations and 0 for below. So information's presented, but we just make the importance a lot lower through the pointage. I'm not sure, I'm just gonna throwing that out as an idea.
We could do that. We would need to adjust the points for the rest of the categories as well, just so, because the idea is that it exceeds in each category, and then multiplied by whatever that is could potentially get them to the total 50 points for option 1. And I do have both documents in a Word copy that I can share my screen as well for the track changes as we go along, Alan. That makes it easier.
Yeah, why don't we share that? And Paul, do you want to make a motion or?
Well, there's so much more to talk about.
All right. Why don't we talk about some of the other things then?
Okay, so what about proctoring? That was one of my others I raised. Getting more.
Sorry, Paul. So the intent was definitely for them to record the live audio and video portion. I agree, it doesn't explicitly say that under the scope, but so let me share my screen now so you can see this.
Okay, so we should just say that.
Yep. So I added a sentence that we can, if we agree with.
A new question. So it wasn't clear to me who's doing the grading.
So this is where, I apologize, I mentioned, so after this, I'll send out a request for 2 volunteers. So we'll have the 2 volunteers.
No, the grading of the exams
Oh,
that are administered.
we'll continue to do the grading.
Okay, maybe we should be clear about that because that is a cost for the applicants or the potential contractors if they have to have. They may have to modify their software to be able to provide grades, and if you're saying they're not going to, it wasn't clear to me in reading this, so maybe we should make sure. And it could hurt us because if they are preparing for that, their price will be higher than it needs to be, perhaps.
You can add that under the out of scope section, that's fine. Assuming the other subcommittee members agree.
I agree with that.
And then let's see. I don't want to be accused of monopolizing this, so somebody else want to
Paul,
ask the.
what's your next thought?
Okay, all right, carte blanche.
Carte blanche.
So in the scoring, I'm looking at page. Let me just share my screen. There's category A, which is responsiveness of the proposal. Does that kind of duplicate the scoring, the aspect we were just talking about, where if they don't respond to a particular requirement, they get, and they have 2 of those, they're out. In other words, does this need to be in here?
So this is one of the standard state bar. So A, B, and D are standard state bar request for proposal requirements. So C is the opportunity that we get to really modify what we want there. And so that's where those 50 points are significant. And the idea was that everything listed under category C, if they get more than 2 or more, either meets or below or not included, then that would not fulfill the requirements for the exam overall.
Okay, so it's basically, this is a standard bar policy.
Yes.
And category A, if I may add, tends to be things, it is where we have asked them as part of their submission, in addition to giving us the proposal that demonstrates they meet the business requirements, it would be submit to us an org chart and of who's going to be working on this and what their experience is. Submit, right? So it's sort of items that they need to include, a cost proposal that allows us to evaluate, right? There are a variety of things that we specifically asked them to submit that go to the sort of the entirety of the proposal in addition to the business requirements.
Okay, so it's the kind of stuff that you're not looking at in category C so much.
Exactly.
Okay, even though it's a policy and we probably can't change it, let me just say that giving 10 points for simply agreeing with the bar's contracting requirements, which there's no choice there. That's kind of an award for showing up. And that seems silly to me, but I'll leave it at that. There's probably a few more bar policies I think are I would change. But so then, okay, there's that. Let me go back here. I was only able to highlight on the PDFs. I wasn't able to. Are you actually seeing my file?
Yes.
Yes.
Okay, so something weird's going on here. So, so grading you clarified, scalability we talked about. Okay, I guess it was in the requirements. So let me go there. Are you seeing that or?
Yes.
Yes.
Okay, all right. So, saying not in scope for June 23 or June this year, maybe it's a little bit confusing. I would just leave that blank because they're not working until October. So they don't care to know, they don't need to know the date in this June or June 26th, because they don't start till October, right? Or
Correct. It was just in for informational purposes, but we can take that and the 2028 one out.
Yeah, for what it's worth, I didn't know what you meant by not in scope. I had to think about that for a second.
yeah, okay, and then the same for the table below. And then let's see. So we say that the deadlines are typically moved, but don't we have a rule that says that they are moved? It's not that's just the way our bar rules work, right?
So not all of the deadlines above are in the rules, which is why I listed typically, but
No, but I think we have a general bar rule that says when a deadline is on a weekend or holiday that it goes to the next business day.
it is
Anyway,
for
it's
the
not a
deadlines
big
set
deal.
forth in the state bar rules. That's correct.
Yeah. So
Yeah, I think Tara's hesitating because she doesn't want to say that we have there are certain we've been talking about certain rules that don't relate to the first year law students exam, but there are rules in statute. There are certain statutes that list dates and have specific dates that do not appear by their language to be intended to move to the next business day. But we have a state bar rule which arguably conflicts with that and having it moving it to the next business day. So I think that's why Tara was being circumspect about that.
okay, this one was just grammar, semi-private room. I think in each case you should say semi-private room or reduced distraction room, just to make it read better. I'll leave that choice to you, but as you know, I can't help but proofread.
Mr. Chair, maybe what we can do is in the passing of the resolution that we can just make clear that staff can make grammatical changes as necessary, and then we can get the things that are sort of purely grammatical from Mr. Kramer afterwards, and we can focus our time on the more substantive discussion.
I was just going to say that, non-substantive grammatical changes. can be.
Okay, works for me.
Okay. Next.
So the vendor's going to be running the sign-up process. That's the gist I got from this? Is that correct?
So it'll continue similar to how it is now, where so applicants apply through the exam. They have assuming that the vendor will also offer remote that we go with, they'll have the opportunity to choose between remote or in person. But then typically the vendors will then work with the candidates to schedule specifically for those in person at which location.
Okay, but they're still using Ames to get it started, right?
Yes, they still apply through Ames. We confirm their eligibility for the exam. If they need testing accommodations, that's all done through Ames.
And so are you anticipating any problems coordinating or interconnecting the Ames to the vendor software?
I don't think so. I don't know if any of the other staff wants to say anything, but typically we're able to export what's in the in Ames and then be able to give it to the vendor in a format that works for them. It's not an issue that we've come across so far.
Okay. What does this last sentence mean? Allotted break time will not include any time necessary.
So for some of the vendors that we've worked with, if we've said we want the candidates to have a 10-minute break, the vendor has taken that to mean the 10 minutes includes break time plus, for example, if it's a remote test taker, the 3 minutes to do a room scan or something like that. So it's just trying to make clear that any set break time is break only for the applicant. It's not to be used for anything else.
Does anyone else think this says this clearly enough, or it's something staff, I guess, could work out with it, explain to the contractors?
Right. I'm not sure it's clear. Shall not exclude any time necessary. The allotted break time will exclude any time necessary for the candidate to receive something like that.
So maybe a parenthetical example, like the one you cited, Tara, would help with that. You could add that. You know, paren room scan or whatever else is involved in that. You're trying to be clear that the applicants get it. They don't have to give up part of their break for this technological stuff.
Exactly.
Okay. Forget about that one. Can't remember what that engendered and triggered for me. Yeah, I worry about room scans, but that's something we can talk about later, I guess, when we're evaluating the proposals. Now, this last one, or this one here, last probably got you excited unnecessarily. What does this mean?
So we've gone back and forth on this a little bit, but so we want to ensure that the vendor does not decide when to disconnect an applicant from the exam. So for example, if somebody is trying to, their computer meets all the requirements, but for some reason they can't connect on the exam day, we don't want the vendor to say, well, it's been 3 minutes, you can't connect. So it would be to allow them to continue trying unless the state bar specifically says, where they're no longer authorized to continue trying to access the exam.
Yeah, I don't know that it says that though. It's not allow candidates.
So I think we can maybe reword it to something about discontinue or terminate terminate testers only upon authorization by the state bar.
Which may cause them to communicate with you more often than you would like if the decision is clear.
Well, but I mean, that's one of the things that we have decided on these exams historically, that we don't want the vendor making the decision that I'm sorry, you've violated this exam rule, you're done, your exam is over. We want them to communicate with us, and we want to be the ones to make that call.
Okay, fair. Talking about basically locking down the laptop. So that they can't access helpful materials.
Correct.
I don't know why I just didn't say cheat, but literally the way it's written, it says that if an accessibility program is approved, then the first part of the sentence doesn't apply. And of course, you don't mean that. You mean that they can't access any other programs except accessibility programs specifically approved by the bar.
So instead of saying unless, it should say except, right?
Yeah. And get rid of the word are. Yeah. Does that make sense?
Mm-hmm.
I would get rid of the word correct in the next one because, of course, the program isn't going to make sure they give the right answer.
Yeah.
It's going to make sure they don't accidentally select two answers.
Right. Yeah, only one answer.
You really mean technical experts, don't you?
Not necessarily. So from our experience, the vendors, they sometimes have a different team who more closely deals with, for example, accommodations, or that deal with the remote proctoring versus the in-person locations. And so it's really whoever they designate for that. I think one of the issues we've experienced before is that we have one centralized person that we're going to, but then they have to say, well, let me get back to you. I have to check with so-and-so, versus like actually having them at the meeting. And so it really is in those different areas versus just technical expertise.
Okay. I mean, we've given that phrase a very specific and different definition in the bar exam, development area. Okay. And then let's see. Okay, that's the next one is just very much a grammatical thing. Okay, we talked about videos. Oh, randomizing of the answers. I'm going to try to be as discreet as I can here, but we have certain tools to detect cheating. And I wonder if the way you're getting this data from them will prevent the use of those methods to detect cheating. Do you understand my question?
I do.
Okay. I would have had discussed this in closed session if we had such a vehicle.
I think that the way the first year is administered, it does not mirror the bar exam and some of the concerns I think you're thinking about, Paul.
Okay, well then, yeah, it's only when randomization was mentioned that I thought maybe we were up to that. Yeah, because I do see the first year exam. It is a for the applicants, it is what's the term we use? It's a very important exam. But for protection of the public, it's not. The purpose of the first year exam is more to allow the students to judge whether they are going to be successful ultimately, and to measure the performance of law schools. But it's the bar exam that provides the public protection.
Yes. Are you just looking to confirm your understanding, or?
So if you're not randomizing, again, that's another feature they may not have to build into their software if you're not going to use it. Might save a few bucks.
Right.
So our experience in our experience, a vendor would submit a bid even if there are a handful of business requirements that they can't meet. Right? They're still going to submit the bid, and so I think that might be one of those issues, randomization, that we don't need to make a decision on today. Do we want to randomize or not? But it's something that sort of remains a possibility, depending on an ultimate policy decision that we choose to make on that.
Okay, I'm just flagging it for you. Disclose a history to whom? It seems to me like some of these disclosures are, for instance, are to the candidates when you're giving them a mock exam. But I would think this history is not for the candidates, it's for us in evaluating the proposal. So I just maybe make that more clear.
Yes, that was the intent. So I can clarify that.
Maybe we should have a catch-all in this lockdown provision and other means by which an applicant might need a better word for cheat, but anyway.
Might access
These are-
unauthorized materials or receive unauthorized assistance.
Yeah. Yeah, there's just one little typo there. If it's at least every 12 months, that's pretty regular. What is if necessary trying to get at here? Seems just part of the regular process. Gonna happen. Not an option.
So the applicants that take the exam remotely, they're required to take the mock exam, whereas candidates who take it in person, it's optional for them. It's not mandatory.
Now they're taking it on vendor-provided laptops, right?
Either a laptop or a desktop if they're testing in person, correct? So that's
No,
why
but
they're
isn't
not
the
testing.
vendor
I'm sorry?
isn't the vendor going to provide the computer if they're testing in person?
Yes.
Okay. Yeah, that was another point maybe I didn't highlight, but why we always say laptop as if that's the only way, but couldn't we just say computer?
We typically use laptop when we're referring to the remote exam specifically, since at least historically we have not allowed desktop computers.
Oh. Oh. Okay, and yet, and also somewhere, I don't know if I flagged it, but oh, maybe it's down here. No, your okay, their software has to work on Chromebooks, and Macs, and something else, Windows, of course. So what's the reason not to allow desktops?
My understanding has just been with past vendors. I think it's been more of a security issue. They're not able to lock them down as much as they are with the laptops. I don't know if you have anything else on that, Gene, but that's my recollection.
Yeah,
I mean, you would have to make it clear they need a camera that they can, rotate. And maybe that's harder with a desktop. But
yeah, I mean, certainly it would be more difficult to do 360-degree room scan with a desktop, but there are security issues that pose more of a challenge with a laptop with a computer than a laptop.
okay, yeah, I'm having trouble imagining them, but that's okay. Okay, I don't know why we need to say that they don't apply to other state bar exams, but whatever. Should we be telegraphing the length of a renewal or range of uh, exams, 1 to 3 additional, or we probably don't know, right?
So I think one of the other ones you're referring to is the legal spec exam. And so Cody and I did talk about whether or not to issue the RFP for both. But right now they're looking at potentially changing that exam. So he's going to be issuing one separately for that one.
Okay, that doesn't hurt, I guess. It just makes me wonder does kind of raise questions. Okay, so what about the option to renew? Do you know how long that might be? I mean, whatever's decided about the bar exam is not going to affect the first year exam.
I think I would go back to whether or not we choose, depending on how where we decide to go with the bar exam, if the committee ultimately wanted to potentially change vendors after this to test somebody else to see their capabilities, at least for the multiple choice portion before contracting with someone else for the bar exam, that could be a reason why. I think we left it as may contain an option to renew, just in case also to see how we're working with the vendor.
Okay. All right. One more document. Okay, we talked about scalability.
And so, can I ask Paul really quickly while you have this up, just so we're clear, since the motion will say refer to the documents as amended, if we can maybe get a temperature check from the other members, whether or not we want to remove scalability and future readiness, or I think as Jillian suggested, was just lower it down to 1 point and then adjusting the other values accordingly.
I would prefer just to remove it and just to do one at a time. Other members?
This is Michael. I agree with our chair.
Okay, thank you.
Julia?
I'm with removing it.
I'm sorry, what?
Oh, I said I'm fine with removing it.
Okay.
We did that too.
So Tara will take that out.
And then we'll just need to adjust the valuation so it still adds up to 50.
Right.
Yep.
I'm going to quit sharing and see if I have anything on attachment B. Basically, I just flagged at the end of attachment B. Well, there's a whole category called scalability and future readiness. So um, uh, sounds like that's coming out.
Anything else, Paul?
No, no, thank you for your indulgence.
Okay. So where are we? We've agreed to remove scalability. We've agreed to allow staff to make grammatical changes later. Paul can consult with staff for those. And anybody else who might have any purely non-substantive grammatical changes. Is there anything else we need to discuss on these?
I had some questions and points, Paula. Are you meaning the substance or just the non-substantive issues?
Go ahead, Julie.
Okay, I'll be short. I just had a question about the out-of-state in-person test takers. How are we asking vendors to address that if we're not sure where those persons will be taking an out-of-state in-person test from, or is that something that we will know ahead of time, or what are we expecting vendors to address for that requirement?
So is the question, can the vendor provide for out-of-state applicants to take it at a location in their state? Is that the question?
It seemed like from my reading that was one of the requirements. So I was just wondering
Yeah.
practically how we want them to address that.
Tara?
So up front, if the vendor is able to let us know, if they have in-person availability outside of the state, and then if we do end up with someone who registers for the exam, what we do is that when we're providing that information to the vendor, then we work with them to find the location that's closest. So we can't, unfortunately, since we can't predict necessarily who will sign up for the exam, we can't ensure that there is a location right there, but at least knowing whether or not the vendor has those options, and if they are in some of the major metropolitan areas outside of the state, that typically helps us.
So it might be a tiebreaker in effect.
It could be. I like the language about the time zone. It doesn't matter where you are. You still need to take it Pacific time.
Yes.
But there are 4 different start times. What's that about?
So based on seat and proctor availability, at least historically, we haven't been able to start everybody at the same time with the vendors. The current vendor, I believe, has a little bit more flexibility with people scheduling between an afternoon and a morning session. So looking at what we wanted, staff was suggesting that we limit it to 4 start times, so 2 in the morning and then 2 in the afternoon. And it's really just about accommodating the number of test takers and making sure there's proctors available.
And it's really only possible because the exam is only a half day now.
Half day, yep. It's only 3 hours at the standard time.
Right.
Julia, I'm sorry. Did you get your question answered?
Yes.
Okay.
I did have another question, or 1 or 2 more. I was thinking that maybe we should ask them about their proctor training, how they're reviewing their requirements with the proctors, maybe provide an example of a module or webinar or however they do the training, just to make sure, that is something that is being addressed as far as, their proctors knowing what they need to do.
How is that addressed, Tara?
I don't think it's contemplated that we ask them for their proctor training. It's more so that they confirm that they will administer the exam in accordance with our rules and policies. And the reason I say that is that we've had some instances where, for example, a vendor doesn't want to allow a specific item, although it's on our permitted list. But we can definitely include, if we'd like, that they provide us with information regarding the training that their proctors undergo.
Well, I don't know whether this actually occurred or not, but I know we got complaints on the February exam that some of the proctors didn't seem to know what was allowed and what wasn't. And again, I have no opinion as to whether that's accurate or not, but we did get those comments. So I'm thinking there should be something in there to confirm that the proctors are trained.
And maybe what it is adding that they need under the deliverables, they need to provide us with a proctor training plan to ensure that they can administer the exam in our way versus like what they do before we get involved in the picture.
And that's an example where they're kind of certifying that they did right by us. But how can we verify that for ourselves? Probably the only real way would be to attend their training sessions, and that's obviously too much. But maybe seeing their training materials, seeing what they tell their people in writing, would that be useful?
Tara, that sounds reasonable.
I think so. So I think we could add in a deliverable that says like proctor training, then we can ask for their plan to train them on our materials as well as providing us with those materials so we can review them.
And what kind of, as the exam is happening, observational participation do we anticipate for us?
I'm sorry, could you ask one more time, Paul?
Well, actually, Paul, before we move to that, Julia, did you have anything else with the proctors? And is that kind of what you were contemplating?
Yeah, that was us contemplating that they provide a copy of the materials, at least for their training. And I was wondering also if we want to require if they use subcontractors for their proctors, if that helps at all in keeping them accountable or not.
Is that something we can just ask during the interview process, or Tara?
I assume so, unless council says otherwise.
No, I was just trying to ask Julian, were you trying to build in a prohibition on subcontracting? Or I sort of missed what you were getting at.
Not prohibiting, but just for the state bar's knowledge, if they will use subcontractors, and if there is questions in the future, who was the proctors, and if they cause issues, then at least we have that information readily, knowing kind of the parties involved in it. If that helps, I'm not sure if that makes things more difficult.
I think, Tara, we could add something like disclosure of any and all disclosure of existence in terms of subcontracts utilized to achieve the deliverables or something like that, so that they have to tell us about them and tell us the terms of those subcontracts so that we know what is being subcontracted.
And we have standard provisions making the main contractor responsible for the work of their subs, right?
I'll double check, Paul. It's been a while since I've looked at one of these, but we can double check that for sure. And this is, again, what you are approving today are the business requirements and the rubric, and of course the contract itself would come after that, with legal counsel being with advising on that.
Julia, any other thoughts?
I think a lot were answered. I guess one more just quick suggestion: when the state bar is doing a trial of the software, if that could include, I think they said 20 people from the state bar will do a trial run. If we include maybe 1 or 2 people testing some of the accommodations as well, some of the screen readers or something else, so kind of the testing that they can meet testing accommodations as well during that trial run.
A great suggestion, Julian.
Can do that.
Okay. Was that it, Julia?
I think that was it for me. Thank you.
Great. Paul, you were talking about observing the exam?
Yeah, our monitoring. Are we going to, maybe it diminishes over time once we are competent, but we need to be, I guess a role for us is implied because they have to ask us for permission to do various things as the exam is happening. But are we going to have some people who are, for instance, looking at the remote proctoring feeds to see how things go? or we just going to wait to, if there is a problem, to look at the recording after the fact?
I think it'll depend on the vendor and their availability. We've had various experiences. I think ones where we can log in live and see what's going on as long as everything's looking, and ones where we can review it after, assuming that it's live proctoring like we're requesting. We can request access, I think, unless Jean says otherwise.
No, the only thing that I was going to suggest is consistent with a recommendation you made before, Paul, is we could add something about the state bar staff's right of access to any physical locations where they're testing. And I think you're right. Once we know what kind of platform, something certainly the subcommittee could ask about is what kind of monitoring is available during the exam. But I think you could build in that right of access for state bar staff for physical locations, state bar staff and CBE members, because I know there is an interest in observing.
Okay, yeah, I mean, we just need to protect ourselves. It's a small enough operation that we have more of a chance to maybe save the day if we catch something early than we do on the 10,000 taker event.
Okay. Were there any other thoughts from anybody on either of the attachments?
So we were needing a decision by the subcommittee on the option for which of the two options to go with for the scoring on the rubric. There were two methods that Tara laid out.
Right. I didn't understand quite the difference. So Tara, could you go through that?
Yes, and so let me bring that up and I can share my screen. That'll probably be easiest. So we discussed with some of our colleagues in the Office of Access and Inclusion, just because they have experience with the rubrics and whatnot. And so one of the things that they do with their folks is that they give them the option of whether or not they want there to be a straight multiplier. So for example, if a vendor exceeds in all of the categories listed above, those would each be converted to 8 points, or so on. But option 2, on the flip side, gives the committee a little bit more flexibility. So rather than just deciding that an exceeds equals 8, you have a range of options. You could assign them 6, 7, or 8. So maybe you thought better than the rest, but they weren't the best that they could be. Then they would still be maybe a 6 or a 7 versus an 8. So I think one is a little bit more of a straightforward option. But we did want to provide you the opportunity if you wanted to have a little bit more flexibility than what the 4 categories of exceeds, meets, below, or not addressed
So
provides.
it's like really exceeds.
Yeah.
It gives you the ability to distinguish a little bit more between the different vendors. Otherwise, you could end up with several of them having the same score.
And we make the scoring after we've seen all the proposals. So we have all of them, and we're not scoring each in a vacuum, but after, as compared to the others. Is that right?
Correct.
Okay, so when you say multiply, so how does this work? So let's take candidate experience, and it's a meets. So do you put a 1 in that column and then you multiply it by 5, or then you add them up and you multiply by 5? Is that the deal?
Yes.
Or-
So 1, yes, X, however you'd mark it on your side. If meets is marked for each of these, then you would multiply by 5, and so they get 25 there. And then again, we'll have to adjust this, but so then you would use that to help create your total out of 50 points possible.
So then we have to do some division at some point, because that could easily add up to more than 50 points. Right? If you put 1s in all the first exceeds category, the first, 5 boxes for at the top there, that would be
40 points and then 10 points for the bottom 2 boxes.
okay. Oh, I see. Okay. And okay. Got it. So we have to move the scalability stuff somewhere, is that?
Yes, so we can adjust those points with the committee's permission, but right now what we're looking for specifically is whether or not you want to leave it at a set amount for each rating or having this range, so it gives you that little bit more flexibility in between each.
I like the range.
Yeah, I was going to say,
Okay, so option 2.
I would support option 2. Anybody else have any other thoughts? Looks like option 2 it is.
Unless there's further discussion, I do have a motion if you'd like me to put that on the screen.
Yes, please.
Sarah, in the final for the result, I'm sorry, that was my error, and what I gave you should also reference the final one. Yeah, the subcommittee on examining. Yep.
Yeah. Subcommittee, yeah. Can everybody see that? Do we need to read it? We don't need to read this, do we?
Dean says no.
All right.
Do we need to say as amended for the second paragraph, attachment B as well? I think, yeah, attachment A is amended, but yeah, matched on. Thanks.
Well, don't we just attach the amended version to the resolution?
Well, we don't have a final version that you're looking on with all of the amendments.
Well, okay.
That's the issue. That's why it's not just attached.
All right. There's no further discussion. Is there a motion?
This is Mike. I'll make that motion.
Thank you.
I'll second.
Dr. Kyle makes a motion. Mr. Kramer seconds. Any further discussion? Final discussion. Devin, can you call the roll, please?
Howe,
Yes.
Gongora, not present. Kramer,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 4 yeses and 0 nos, the motion passes.
All right. Thank you. Good work, everybody. There's nothing on closed session today. If there's nothing further, I'm going to adjourn the meeting. Thank you, everybody.
Thank you, everyone.
Thank you.